Welcome to the 46th meeting of the Committee for Justice. The meeting is now open to the public. We have a considerable number of officials outside, so doubtless they'll take a minute or two to get seated. Members, you're reminded that the committee meeting is going to be recorded and broadcast throughout Parliament buildings and online. And as ever, we're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence our approaches to matters under consideration. Any member who has an interest to declare in relation to today's business should do so now, or when the particular matter arises in the meeting. Does anybody have an interest they wish to declare? Could I declare that I have an immediate family member who works in the legal profession, and a number of us will declare that we're members of the APG on access to justice. Apologies. We have an apology from Danny, and I know that Doug and Connie, who are with us online currently, have provided apologies for the event which follows today's meeting. I presume there are no... Morris?
I have an apology I have to...
Appreciate, Morris, you've got another appointment. And as members, as you can see, then we've got Doug and Connie virtually, as I mentioned. Agenda item 2 is draft minutes. You'll find those in the meeting pack at page 5, and those are the minutes of last week's meeting, which was the 26th of June. Are you content that those minutes are a true and accurate reflection of last week's meeting?
Content, yeah.
Great, then I'll sign them, thank you. Agenda item 3 is matters arising, and there's none. Do you have any? No, thank you. Agenda item 4 is the Crime and Policing Bill, and it's a second legislative consent memorandum, and it's a written paper from the department. I would ask you to turn to page 19 to 34 of your pack, please. You'll recall that the committee previously considered and agreed to support the Justice Minister in seeking the Assembly's consent to extend a number of the provisions in the Crime and Policing Bill, which was introduced in the House of Commons in February, to Northern Ireland. The committee's consideration of the LCM and the department advised that at the time the department advised a second LCM might be required. So the department has now provided a written briefing in which it sets out a list of further provisions that require legislative consent. They've advised that the list may change over the summer period, and the written briefing has been provided to ensure the committee is informed of the position in advance of summer recess. The further provisions that currently require legislative consent are as follows. We've got child exploitation offence and civil prevention orders, restrictions on granting replacement driving licences to registered sex offenders, an offence in relation to fine-tuned AI models designed to produce child sexual abuse material, essentially image generators, child abduction, stalking protection orders on acquittal and conviction, new stalking guidance about disclosure of information by police forces, barred and advisory lists, access to remotely stored electronic data, strengthened age verification requirements for the online sale and delivery of knives and crossbows, and provision regarding the bulk and suspicious sales of bladed articles, and removal of the supervision exemption from the definition of regulated activity, and that's a measure for the Department of Health. More detail on each of the above measures is provided in Appendix A to the Department's paper. And I should tell you that although the timing of the second LCM is dependent on how the bill progresses at Westminster, it is expected that consent will be sought after the summer recess. So a formal evidence session on this second LCM is going to be scheduled for the 11th of September, and that will be the first committee meeting to follow summer recess. Are you content to note the department's written briefing and to revisit the matter at the first meeting after recess when we've got more up-to-date information? Or do you have any questions now? Because as you can see, we've got departmental officials in the gallery with us who are willing and able to take questions should you so require. Deirdre.
No, thanks, and thanks for the update, I suppose, from the department as well in advance of summer. But obviously, I mean, discussions are still ongoing with the Home Office. Obviously, we would have been interested in issues around the access to remotely stored electronic data. But I would also be keen that when we get the briefing in September, if we can also get any feedback from the Human Rights Commission pertaining to the LCM matters as well, that would be good.
Thank you, Deirdre. Members agreed to that? Could the officials maybe tell us, have they already spoken to the Human Rights Commission?
On the RSCB one, yes, we have. We've shared the draft policies with the Human Rights Commission. They noted that the power was novel, but they considered that it could be there was a potential issue around privacy Article 8 rights. It would engage Article 8 rights, but that could be, that could be considered legitimate if it was for a legitimate aim and it was, the interface was necessary and proportionate. And that's the way the clauses have been drafted. That it's very much access to data where for very specific purposes and necessity and proportionate are built in right through that. And the Human Rights Commission noted that the code of practice will be very important in ensuring that appropriate safeguards are in place. Will we continue to engage with the Human Rights Commission whenever the Home Office start to engage in a draft of the code of practice?
And Chair, I should say we probably will plan to send an overall LCN package of the draft clauses to them, and then each policy area will also address them individually.
It's helpful, both of you. Thank you very much. Can I just check that you guys online could hear that?
Honestly, Chair, not really. Because obviously they weren't speaking into a mic. I didn't catch some of it.
Never heard a word.
Yeah, it would be easier. Yes, please. Thank you. We'll try not to kind of cause too much disruption, but just it's a wee bit easier just for the folks online. Thank you.
It's just to advise that we will collectively plan to send the Human Rights Commission the draft clauses overall, and then each policy area individually. As and when needed, we'll interact with them individually. I think Lisa had indicated you were already in touch with them.
Yeah, we've been engaging with the Human Rights Commission on the draft clauses relating to RSAD, and they had advised that it would engage Article 8 rights around privacy, but that can be legitimate if it's for a particular purpose and it's legitimate aims. So they just noticed that the code of practice will be important in terms of making sure that the appropriate safeguards are in place. So there's a requirement to prepare a code of practice and for the Home Secretary to consult, including with the department, before the code of practice is put in place. And that will be in place before the powers are commenced, and we'll be engaging with the Human Rights Commission as we see progress and as we're engaged on the code of practice. So they just noticed the importance of the code of practice in ensuring that human rights issues are safeguarded.
That's great. Thank you, Lisa. Deirdre, you want to come back in?
Yeah, no, it'd just be useful for the September briefing if we can just have that in black and white. And also then in terms of the interaction around Article 8 then, how you do see that as being proportionate and necessary against those rights as well. So just if we can have more information, if it's available by then, obviously in terms of the discussions that will be ongoing between the department and the Home Office, that would be useful.
Thanks. Agreed, yes. We can leave that with you guys for now. Thank you. Does anybody else have any further questions on this second LCM? Justin?
Very quick, thanks, Chair. What's RSAD?
Remotely stored electronic data, so it's data held in the cloud, because where before data would have been held on the device, now more and more commonly a device is accessing data that's held in the cloud. So it's being able to, it's clarifying the powers for law enforcement to be able to, whenever they have a warrant to go and seize a device, when they're investigating a criminal offence, that there's clarity in the powers for them to also seize data that's stored remotely that's been accessed by that device.
Sure.
That's great. Thank you, Justin. I just had one query around. Does anybody else have anything? No, all good. I just had one query around child abduction. Not sure who that is. It's Maura. Maura, thank you. It's very straightforward. I just want to check that I've got the gist of this. So the general gist here is that in circumstances essentially where a parent might have permission to take their child abroad, say for example for a holiday, returns potentially to their homeland but doesn't, then keeps the child out there.
Yeah.
That's what this is moving to address, is it?
Yeah, so it's closing a gap really that was identified through a legal case where an individual took a child to another country, and it was exactly those circumstances, was taking them on a holiday and then stayed there with family members. And the court determined that because the wording of the offence included the words taking or sending, the fact that when he left, it was legal for him to do so because he had consent to take the child on holiday. So it was the continued detention that was illegal. So the court determined that the offence wasn't capable of capturing those circumstances. So really what this amendment's trying to do is to close that gap so that that's covered.
No, that's fine. I just wanted to make sure. And in terms of those issues, then if that carries on and works through, how is this going to work if other countries are not prepared to extradite people? Because they may face criminal charges here, but that doesn't mean they'll come back here to face criminal charges. So what happens?
Yeah, it's certainly not a panacea, because where you're trying to conduct law enforcement across countries, it's always going to be challenging. So it's going to rely on, I suppose, investigative authorities here trying to work collaboratively with the authorities in other countries. But even though that's difficult, we're hoping the fact that the offences there could act as some sort of deterrent, and we felt that it was still merit in strengthening the law in that area in line with what's happening in England and Wales, just so that people here have the same access to justice.
Yeah,
but no, I totally accept that it's difficult in practice, and it's an incredibly emotive issue when two parents want to hold on to a child, and the other country maybe is sympathetic to their citizen. It's always going to be difficult. So we're not claiming that this is going to prevent this type of thing happening, but at the very least we're hoping it'll be a further disincentive.
Well, absolutely. I mean, it's another step along the road, and certainly closes the gap, and I hope at least it goes some way to working, because I know it's very distressing whenever, for families whenever that happens. So thank you very much, Maura. That's great. Does anybody have anything further? No. I think then more or less we're content to just wait and see how things progress. We'll get the full briefing in September, and should we have anything further then, we'll come back to you. So thank you all very much. Really appreciate it, and I'm sorry that we took up some of your time there, but thank you all for coming. We greatly appreciate you all being with us today, just in case. Thank you very much, everybody. Really appreciate it. Thank you.
Bye.
Agenda item 5 then is the Border Security, Asylum and Immigration Bill. Could I ask you to turn to page 36, please, members? The committee previously considered and agreed to support the Justice Minister in seeking the Assembly's consent to extend a number of the provisions in the Border Security, Asylum and Immigration Bill to Northern Ireland, and obviously this bill has been introduced in the House of Commons in January. The Department has advised that owing to a proposed amendment to the bill, constables of the PSNI may be included within the scope of the definition an authorised officer in relation to clause 19, which relates to powers of search in relation to electronic devices. The Department has advised that its legal advice states that even though they may affect the PSNI, because the relevant clauses are in relation to the search and seizure of electronic devices regarding immigration matters which are accepted, a legislative consent memorandum is not required, and the Department has stated that its legal advice concurs with the Home Office's assessment. Members, can I have your agreement to note the paper from the Department, or do you require any further information or clarification on this one? No? Content to note? Thank you. Then we've got agenda item 6, which is the SL1 on PACE, the Police and Criminal Evidence, Northern Ireland Order 1989, Codes of Practice Order 2025, and that starts at page 38. Members, the Department is proposing to make a statutory rule under powers conferred by the Police and Criminal Evidence Northern Ireland Order 1989, known as PACE-NI. That order provides the statutory framework for police powers in Northern Ireland, and Articles 65 and 66 of the order impose a duty on the Department to issue codes of practice that regulate the exercise by police officers of these powers in the investigation of crime, and set out safeguards and protections for members of the public. It's proposed that the rule will be subject to the negative resolution procedure. The committee has considered this proposal for the statutory rule across a number of meetings, and we had sought further information from the Department, the PSNI and the Police Federation. Responses from all three are included in today's meeting, pack, but I do want to draw your attention to the fact that yesterday evening the Police Federation withdrew their initial response, indicating that they wanted a bit more time to consider. Now, honestly, that seems fair enough to me, and we'll come back to that in a second. Members, you'll remember that the Ministers proposed two options for progressing the PACE codes. Option 1 is to await the Equality Commission guidance to consider any amendments required and bring forward a complete revised package of PACE codes. Or option 2 was to put in place interim annexes which make it clear that while under review, it's for the chief constable to decide if a person should be treated as male or female for the purposes of a search, and the dignity of all parties should be respected. Before I ask for your views on this, does anybody have any comments that they want to make? I'll start off, if you wish, by saying that the PSNI's response indicated that they weren't content for the Chief Constable to have the responsibility for the decision on the basis that the Supreme Court had already ruled. We know now that the Equality Commission intends to seek clarity through the High Court. The Police Federation is also concerned that they've got a few issues and they want to look at those again. And to be honest, as do I am not clear that what the Minister indicated in the meeting with us and that she indicated was contained within the NPCC documentation is actually reflected in the code. Because at that time, and you'll see from the minute of our note, that it was indicated to us that the process would be for searches that where a detainee was being searched by a person who was not of the same biological sex, the detainee would sign written consent. The searching officers would sign their written consent, and that the authorising officers would also sign their written consent. And none of those processes are contained within the code. And instead we're back to what's your preferred gender, how do you live? And to be honest, I think for the sake of the people impacted and also the PSNI, I think the code itself needs to be much clearer on the basis that it is the code that will take precedence in the law over the guidance. And that's my view currently. Does anybody else have a comment they wish to make?
That view means that we wait for the advice from the Equality Commission?
Well, that view, I think, means we can have time to... We don't know, we've no timeline, Justin, for when the Equality Commission is going to come back. And that may be a year, which potentially could be too long. And we are mindful that there's a gap at present. I think we could await a response from the Police Federation to see kind of what their concerns are. And now, if I highlight my concerns, I'm conscious that Lisa's in the room and she can kind of take that back. But what's there now, I think, is not sufficiently clear in terms of the meeting that we held nor the NPCC guidance.
Chair, can I just point out that the revised version of the and we brought the initial version and then we took that away, and after the meeting between yourself and the Minister, we came back with a revised version from the annex, and that revised version was agreed with the PSNI, and they've given us feedback to adjust that. I know the PSNI knew that the Chief Constable can't determine, it was not for the Chief Constable to determine,
Yes.
but the word that's now included in the revised annex has been agreed with the PSNI, and we took on board their feedback in finalising that word. That word has been agreed with the PSNI.
That's fair enough, Lisa. And yes, I understand it, because that was the next point in their letter actually indicated we note that you've taken on board our amendment. The issue for me is that what was outlined in the meeting is not what's outlined in the code as it sits, in terms of what those protections would be. We were told that there was potential for the Chief Constable to follow NPCC guidance.
That's the Chief Constable, so it's
It-
in the code, but then it's for the Chief Constable to decide how that's operationalised, and that would be taken in front of the NPC.
Yes, I understand that, Lisa, but the issue for me is that that code as it currently sits is not clear. It's not sufficiently clear in terms of the NPCC guidance that the department wouldn't let us see. But what was indicated was there would be 3 sign-offs, and that's not contained in the code. And no matter what the guidance is from the NPCC, the code would take precedence in any challenge. This is an evolving area of law. It is complex in nature. There is likely to be challenges around it, and I would much prefer, for the protection of everybody, that it was much more clearly laid out than it currently is in that code, because that code as it currently sits, certainly my party couldn't agree to. So
we wouldn't include in the statutory code reference to NPCC guidance. That wouldn't be.
no, I understand that, at least no, but I'm not asking you to include reference to NPCC guidance. I'm not asking you to include the reference to NPCC guidance. I'm asking you to include the specifics of it in the code. Because as far as I can understand, the codes are supposed to align with the guidance.
I think the problem we have is that's an interim guidance, and we have to see the kind of the Commission's work to clarify the legal position here.
Yes, Lisa, and I get that, but it can still be interim guidance whilst being clear that the detainee has to sign, the officers have to sign, and the authorising officer has to sign, and it doesn't do any of that. So until that clarity is there, at least, and until some of that other stuff is removed from it, we're not in a position to support that just yet. So we're content if you want to take that away. I mean, certainly those are our issues with it. I'll bring in Connie, and I presume, Deirdre, you want to speak on that too? Connie?
Thank you for bringing me in, Chair. Just to say, I am struggling to hear Lisa as she's not at the microphone, and
Lisa, come on,
I have
Lisa.
also just had a message there from someone watching the live stream to say they can't hear either. So if it's okay for any further questions, if Lisa could come up to a mic, just so people online, I don't know if Doug's having the same issue. I appreciate what you've outlined, and I did catch some of what Lisa said there. And I think just from my perspective and my party's perspective, we would be in favour of option 2. I think mainly because it makes clear that it's interim annexes while then we can update it once we get that further clarity from the Equality Commission. So just from my perspective, I would be in favour of option 2.
Completely understand that, Connie, and I know that that's your party's position, so that's not unexpected. The issue for me is that it is 10 years since this code was last updated, and despite the fact that there should have been updates in the course of that 10-year period, it didn't happen. So this interim guidance could sit here for dear knows how long, and we don't have any timeline for when the Equality Commission could come forward. So on that basis, as this currently sits, it's not clear enough for me, and I'm not prepared to buy in. Deirdre?
Yeah, no, I think, well, our issues are different, but obviously on the back, I mean, I would want to see the Equality Commission guidance and stuff as well. And obviously, I mean, we don't want policing having to take what's seen as maybe political decisions or what could be seen as contentious as well. So I'm obviously conscious of that also. Our key issues are, as was stated at the meeting on the 22nd of May, in terms of some of the powers not pertaining to that judgment around stop and search, and we asked for more information. The letter that came back from the department in the pack dated the 26th of June basically says that there's been no engagement with the Home Office on those issues because they're reserved matters. Now, we're not willing to take a decision on this without the additional information that we asked for. The reality was we were told that when we were looking at these codes, the only thing that we were signing up to or voting on was the suggested amendments that were coming forward. But when we had the briefing from the Examiner of Statutory Rules, she brought clarity that we're actually voting on the codes in their entirety. And when you look at the SL on that, it is the codes in their entirety. So I'm not happy, and I wouldn't be in a position without that information to vote on the codes. And I just want to put that on the record. And I suppose on the other issues, I mean, we would be keen, I don't know when the Equality Commission is going to come forward, but we'd be keen to see that guidance as well. So just to note that also.
Okay, I don't know if Doug or Justin want to comment on this, so we've got comments from all the parties.
Our position would be that we would be preferable that we wait for guidance from the Equality Commission.
Thank you, Justin. Doug?
Yeah, I think guidance from the Equality Commission is a right way to go. My concern, and you've already laid this out, Chair, is how long we're going to wait until that guidance comes out, and what do the police do in the meantime if this is going to be a year. We need to have something we need to have something in there that the police can use, because at the minute they're going to have to use what they have, which is laid out in front of them. The fact is that they are looking at the NPCC as their interim guidance. That then part of me thinks that, without mentioning the NPCC or the exact words, but that's the guidance, of the interim guidance that should be in it, so that they have something to work off. But if it's not in it and it's not in there now, then we certainly can't support it at this moment in time, because it doesn't give the police any protections whatsoever. My concern is what happens if this takes a year. What do the police do, and are they open to retrospective or any future litigation against them?
Thank you, Doug. I don't know. So I think essentially, Lisa, from our point of view, I mean, you're going to need at least one side of the house on board to get this over the line. And from our point of view, the stuff that's contained in that should more accurately reflect the guidelines than it currently does. The stuff that's contained in that now, I'll be honest, is too much. Whilst it says it's under review, there are too many choices in there, and it doesn't accurately reflect the changed legal position around biological sex.
I think that's part of the problem, is that we're wanting to consider the changes that are needed once we see the Equality Commission guidance.
But in the interim period, there's NPCC guidance, and whilst, as Doug rightly pointed out, and as I pointed out earlier too, it doesn't need to be specified that it's NPCC, but some of the processes need to be much clearer and take account of the position that we're in, because to be honest, I don't think we can buy into circumstances where it says what's your preferred option. People have biological sex and some people have gender certificates and so on. So I think that there needs to be a bit more negotiation around this. Is that okay?
We'll take, then we'll come
Yeah,
back.
look, but Lisa, I'll be very clear. I too am mindful of the gap that exists for the PSNI. It is not my intention, I don't believe it'll be the committee's intention to drag this out longer than is necessary. But you'll appreciate this is a complex issue and we want to get it right and make sure for everybody concerned that it's as clear as possible. So we are mindful of that gap and where it leaves the PSNI, but we're also mindful that there's been a gap for 18 months prior to any of this being brought forward, and it wasn't urgent then. So the department took its time and we need to take our time to make sure that we can get this right as far as we can and try and get at least one side over the line. Deirdre?
It's just that there are outstanding requests for further information. So again, I just want to stress the importance of even under the reserved space, because the reality is we're here to approve the PACE codes in their entirety. And
Can you
unless
clarify
we
what
have
you
that,
consider to be outstanding? Because as far as we can tell, we've covered all the queries that were submitted to us, so I'm not
wasn't, and
quite
we
sure
put
what's still
further in the
outstanding.
letter saying, because at that meeting on the 22nd of May, it would say that you would have to go and speak to the Home Office on the issues that were raised. Then the letter that's come back on the 26th from the DALO says that they're advising that they've not had any discussions with the Home Office
We checked back on the
in terms of
Hansard
stop and
the-
search, the reserved matters, and you're saying because they're reserved, it falls outside, albeit when we got the legal advice from the examiner statutory rules, we're here to vote on the codes in their entirety, because we were also told at the advice session that we're only here to vote on the proposed changes, and that's not the case. We're here to vote on the entire codes.
So we checked back the Hansard of the meeting of the 22nd, and we can find no record of what we said we'd engage Home Office on, so I'm just not sure what that was relating to.
Well, I'll communicate directly, but there was agreement that it would go off, so we can do, but there's outstanding information that we don't have the answers to. Both the Home Office and also the PSNI stuff as well hasn't been fulsome in terms of the responses to all the questions that we submitted.
As I say, we went through all the questions that you submitted and provided the responses, so I'm not sure what you were
You
expecting.
said at that meeting that you were going to go and speak to the Home Office, and then in this letter it's saying you aren't doing that.
As I say, I can't recall or see anything in Hansard what we said that we would talk to
We
Home
were
Office
also
on. I know
told-
that we said that we'd address the question, so I don't know if there's been some
Deirdre,
misunderstanding.
what is it that you want them to go to the Home Office? What do you want to speak to the Home Office
Questions were
about?
submitted, so they were all put in. A few weeks there was a whole series of questions, but we were also told that we were only to vote on, that our position as a committee was only to agree to the changes or not, and that's not the case. We're here to sign off on the entire codes, and that was not reflected from the department. We were told by the department we were only here to vote on the changes that the department were bringing forward, and that's not the case. We're here to vote on the codes in their entirety. That's what we're signing off if we sign off on the SL1, because it sets out the codes clearly. It doesn't set out the changes. It sets out the codes in their entirety.
We provided a summary of the changes, and would probably give them. Obviously, we provided the codes as a whole to see, so you can see the full document.
Legally, the
context.
examiner's telling us if we agree to the SL, you're agreeing to the codes in their entirety, not just the changes. But we were told at the committee our role was only to approve the changes, and that's not.
That was the department's understanding, and the department's position. The examiner obviously has a different position.
Yes, she
So
does.
you do
And I
that.
suppose that's all I'm stating.
It might be helpful, I suppose, to, if Lisa, just to alert the minister to that, you know, that's kind of where we are with things. Could I check, in terms of adding some of the details from the meeting and around the NPCC guidance to the code, would that require full consultation?
I would need to clarify that, because normally there's a requirement to consult before we would bring updates to the codes, and obviously we've been through that process now and we had made changes in light of the consultation. I would need to clarify that.
Because just if some of that stuff could be added in to the
Mhm.
code and some of the other bits and pieces that are under review taken out, that actually might see our way to get some progress on it from some ends. But so our position is that it needs to much more accurately reflect what's contained within the NPCC guidance, and that's our issue around the Supreme Court stuff. Sinn Féin's issues are different. Doug's issues are similar to mine. Justin is looking for the Equality Commission's response, as is Sinn Féin. We certainly have an interest in that, but we've got a bit of room there. So that at least, I think, gives you a bit of clarity for now. Ultimately, Lisa, we're in the summer anyway, so the 28-day rule and so on would apply. So, you know, I think we're better to try and get this right.
Yeah, no, appreciate that.
Is that okay? Thank you very much indeed.
Thank you. Okay.
So are members content with that then? We'll move on.
Yeah.
Agreed.
Right, thank you. Agenda item 7 is SR 2025-113, the compensation orders, disqualified directors proceedings rules, Northern Ireland 2025. The department had led SR 2025-113, which can be found at page 136 to 148 of the meeting pack. However, it was subsequently reminded that there was an error in the rule, and in order to correct it, it was subsequently determined there was an error in the rule, and in order to correct it, it was necessary to lay a second rule, which includes the necessary amendment and also revokes the first rule. The revised rule, SR 2025-121, the compensation orders, disqualified directors proceedings number 2 rules, Northern Ireland 2025, is what will be considered today, and can be found on pages 3 to 13 of the tabled pack. The Department for the Economy is the policy lead for insolvency matters, and this statutory rule is made with the concurrence of the Department for the Economy, and as it affects court rules, with the concurrence of the Lady Chief Justice. The rule will make provision for a procedure to be followed by the Department of Economy when applying for a compensation order under Article 19A of the Company Directors Disqualification Northern Ireland Order 2002, or CDDO, or by a person subject to a compensation undertaking when applying under Article 19C of the CDDO to have the undertaking varied or revoked, and by the High Court when hearing such applications. And again, the rule is subject to the negative resolution procedure. At our meeting on the 27th of June, we agreed that we were content with the proposal for the statutory rule. Sorry, it was 2024, by the way. 27th of June 2024, we agreed we were content with the proposal. And the department has confirmed there's been no change to the policy content since that SL1 was considered by the committee. The examiner's statutory rules has not yet reported on the rule. Do members have any comments, or are you content with the statutory rule?
Content.
Everybody content?
Yeah.
Right. Now that you're content, I'm going to put the question. So the question is that the Committee for Justice considered SR 2025-121, the compensation orders, disqualified directors proceedings number 2 rules, Northern Ireland 2025, and, subject to the examiner's statutory rules report, has no objection to the rule. Are members agreed?
Agreed, yeah.
Thank you. Agenda item 8 is Justice Bill written papers. Item 8.1 is the department response regarding NIACRO's oral evidence session. You might recall at our meeting on the 8th of May, we received oral evidence from NIACRO on the bill. It just seems so long ago now. Following the evidence session, we agreed to ask the department for information on several matters. The department's response is at page 150. Are you content to note that response, or do you require any further information or clarification? Content to note for now? Thank you. 8.2 is another departmental response regarding the scrutiny points raised in Raises Rehabilitation of Offenders and Restorative Justice Amendments papers. Again, at our meeting on the 8th of May, we considered the Raises paper on the proposed rehabilitation of offenders and restorative justice and agreed to forward the papers to the department for response to the scrutiny points included. That response is at page 160 to 169 of the pack. A written update from the Department on Restorative Justice and the interim protocol lead has been included on the forward work programme for the 11th of September. Are you content to note that response, or do you require any further information or clarification at this stage?
I think, Chair, just to note it at this point, but obviously when we get the evidence back in from some of the restorative groups and stuff, that we can come back to some of it also.
Okay. Members content with that, yes? Yeah, thank you. 8.3 is DOJ update regarding taxation reform. At our meeting of the 29th of May, we considered a paper from the department that provided an update on taxation reform, and we agreed to ask the department when the consultation regarding taxation reform would take place and how the proposed consultation proposals relate to matters that have already been included in the Justice Bill on taxation. And you'll see the department's response at page 170. Are you content to note that, or do you have any further information or clarification?
Note.
Note.
Yeah.
I must say I struggled with that letter a wee bit. It wasn't that clear to me, I will admit that. But I presume, as we're working our way through the bill, particularly we haven't really looked at taxation much. Once we get to look at that, if there's other issues, we can
Refer
take it
back
forward.
to it, yeah.
8.4 is a letter from John Wadham, who is the Northern Ireland Policing Board's Human Rights Advisor, regarding children and young people accessing a solicitor whilst in custody. You may recall at our 12th of June meeting, we received oral evidence on the bill from John, and during that session he agreed to check the issue that was raised about children and young people accessing a solicitor while in custody. He was going to raise that with the policing board. You can see his follow-up response there at page 174. Are you content to note that, or do you require any further information or clarification or action around that?
Yeah, sure.
Deirdre?
Yeah, no, I think, his evidence was very good, and obviously this follow-up, I would be keen on his last paragraph there, just where the Youth Justice Agency and the Children's Law Centre did raise concerns in terms of children and young people agreeing to diversionary outcomes, and I suppose their level of understanding, if we could correspond with them again just to give us a bit more information on what their concerns were, because I think it's one of the issues around the maturity and stuff of children and young people when they're in a custody scenario. And do they have all of the information? Do they understand it? I think it even crosses over in times with live links, and do they actually understand the process?
Yeah.
So I'd be keen just on the back of that. I know he said it was highlighted in his report, but if we could communicate with both those organisations, just if they can provide any more information on that point, that would be useful.
And I think not purely around diversionary outcomes,
Yeah,
but
no.
also around the custody and questioning setting.
Yeah.
So that we can actually get a holistic picture around that. Are members agreed?
Agreed, yeah.
Thank you. Item 8.5 is correspondence from Professor Kevin J. Brown, which is an offer from Queen's University in Belfast, and it's an offer to provide evidence. You'll find correspondence from Professor Brown at page 175 to 186 of the pack. Professor Kevin J. Brown is a Professor of Criminal Law at Queen's University in Belfast and has offered to provide evidence to the committee on the proposed amendments to the Justice Bill to repeal vagrancy legislation, and a copy of his submission to the Department's consultation on this matter has been included in the pack for members' information. Do members wish to accept this offer, and if so, would you wish to hear oral evidence or further written evidence?
We should definitely accept, and I think preferably would be oral evidence when we're taking an oral sessions.
My feeling on this is I think we've got some work to do around the repeal of vagrancy stuff. We certainly will need to be hearing from the police. I think we'll need to be hearing from the councils, and certainly a couple of those Scottish councils. I think it would be helpful to include Professor Brown in that, but obviously he's coming at this from from a criminal law perspective. So it might be helpful to, I think we need to maybe stage who we're going to hear from there so that we can get the right questions to the right people. Because some of these evidence sessions might afford us an opportunity for questions, and actually I think that Professor Brown might be a good person to bounce some of those issues off in terms of, okay, well, what legislation might be helpful in this situation. So we're content with that. I think we can maybe look at that as we go to look at the repeal of vagrancy issue, but certainly we're content to hear evidence. Yes.
100%.
Okay, thank you. 8.6 is request for further information. That's page 187 in the pack. And that's just the usual document that the team keeps for us about letters we've sent and around information we're looking for. Members content to note that? Thank you. 8.7 is a response from the Scottish Biometrics Commissioner. You'll recall last week's meeting we agreed to seek clarification from the Biometrics Commissioner in Scotland on whether Police Scotland release photographs after an offender has been convicted and what the implications may be for retention requirements. Dr. Plaster's response is at pages 15 to 17 of the table pack. Are you content to note that for now, or do you require any further information or clarification?
Note for now, Chair. I think it was useful, particularly around, I think it just strengthens the argument that photos should be included, but I think the note for now, and then we can come back at it when we're going through biometrics again.
Yeah, absolutely. I'm certain it's not the last time we'll have that conversation. Okay, are members content then? We're noting for now, yes? Members, just to advise then, so the bill folder has been prepared by the committee staff and that's going to be issued to members in the coming days. We're reminded not to take notes on that document because the notes will be overwritten as new documents are added to that folder and the folder's reissued. So whatever notes you're taking, don't take them on that folder. Keep them separate or you'll lose everything as that's updated, okay? That's going to be quite the folder, I would think. Did you want to come in on that?
I was going to ask because I wasn't sure if it was electronic or not, but it is. And does that include all the papers and correspondence? Is it all, yeah, everything?
Right, yeah, through you. It includes everything. It'll include the legal advice. It'll include everything that they've received so far. And actually what I just wanted to say was obviously there are responses that haven't been due back before this final meeting. So what we might do is issue it now and then maybe reissue it again towards the end of July. I think probably most things should be in with all the updated correspondence, and then that correspondence that we receive between now and then will obviously be included in the pack on the 11th of September in case you want to follow up on anything there. But it does mean you'll have everything on the bill as much as we have as possible through the summer.
Okay. Agenda item 9 is mental health courts, and it's a written paper from RAISE. I'd ask you to turn to page 215 of your pack. You'll see that RAISE has prepared a paper that provides an overview of the mental health courts. Are you content to note that paper for now, or do you require any further information or clarification? Ciara?
I suppose first of all, I'd just like to put on record our thanks to Sabrina for forwarding the paper. It was really, really useful. As you can see from the paper, we're gravely concerned, and we have as a committee are gravely concerned, particularly where the PSNI cases have doubled in the last decade, where 3% they're saying are crime related. The rest are health and safety and mental health. We did have the meeting around the right care, right person. I have wrote in to both departments, personally myself, received responses and they're still very sketchy. I would like to kind of find out from the Silver operational group what are the subgroups that they have set up and what is the progress and timelines to them. So that would be one key area, and I know we're going to go to that probably in September when we're doing a strategic review of the committee, where I think that's probably a key issue that we will be looking at. But I suppose secondly, we are well aware of departments are also going to be looking at their budgets, particularly planning a 3-year budget. So I would like to know specifically as well from both departments, what collaboration are they currently prioritising as departments, particularly in relation to mental health, and is there any cross-departmental work being done to prioritise this and also prioritising it within their planned budgets moving forward.
Yeah, I'm glad you went there because I was afraid that if it would just stuck with what are you currently prioritising and collaboration would just get what we already know, as opposed to they need to be expanding this way beyond that.
Yeah.
And I mean that meeting that we had was, how long ago was that meeting? November maybe. So we're a considerable number of months on And to be honest, I would like an update as to where the work is. So, and I think it'd be useful for us to have that, and to have those responses for our strategic planning day on the 25th. Are members content that we would write and seek that information from the departments, Deirdre?
Want to add, is it worthwhile even communicating that with the health committee as well, to
Yeah, I
keep
think
them
so.
in the loop, and even the RAISE report, so that they can?
Yeah, I think so, and there may come a point where we need to have another meeting about this, to be honest. I think we should, but I think we should take our time to have a conversation first at our strategic plan day. Justin?
I'm just conscious of the notes here where they say there is still a lack of in-depth research and empirical data to fully assess mental health courts' effectiveness. So we'd like to, can we commission more research as to their effectiveness, or can we seek more research as to their effectiveness? And also the fact that it relates only to severe mental health, how is that qualified and quantified?
Yeah, that'll be useful to know. In terms of getting additional data, where would we go for that? Court service?
Chair, I think what the paper is saying, that there is no, with no empirical data, it means that there have
just
been no
isn't.
studies elsewhere, really, for them to draw on. So I think what it would require would be primary research, and I'm not sure that that would be something that our research would necessarily be
Fit to do.
would do. Not that they're not fit to do it, but it strikes me as it might be something that's
Oh, you're
a lot
spending like a
broader,
university or something,
yeah,
maybe?
yeah. But we can check.
I think mine, I put forward questions last week in relation to the overall report, where the department, under the mental health courts, in their review, had a recommendation that they were looking at, some model that they were looking at. So we could pull that out again. Just, I think I might have put the question in anyway through yourselves. Last
Improving
week,
health,
mine, no,
the
they-
improving health
Yeah.
report, yeah.
Aye.
Well, if they're saying there's no empirical evidence for now, I suppose if we get them to take another look and see what additional stuff there may be. And what was your second question, Justin, about what's severe mental health and how's that determined? Yeah, we can.
Threshold, what's
Yeah.
the criteria? And
Members content to ask that? Yes.
Yeah, yeah.
That's great. Thank you. Is there anything else on that you want to raise? No.
No.
We'll come back to this whole issue, I think, on our strategic planning day. Okay. Agenda item 10 is correspondence. There's a correspondence memo and 15 items of correspondence starting at page 230 of the pack, and one item of correspondence at page 19 to 27 of the table pack. I'm going to draw your attention to a number, and then I'm going to open the floor as ever for you to comment on any other items in which you've got a particular interest. Item 10.6 is correspondence from the Committee for Finance at page 242, and that's a call for evidence on the Administrative and Financial Provisions Bill. There's no provisions in that bill for the Department of Justice. Are you agreed to provide a nil response?
Agreed.
Item 10.7 is correspondence again from the Committee of Finance at page 274, and it's a call for evidence on the Northern Ireland Fiscal Council Bill. Are members agreed to provide a nil response? Agreed?
Agreed, yeah.
It's all a bit quiet there. Item 10.10 is correspondence from the Committee for the Executive Office, starting at page 331, and that's a call for evidence on the inquiry, mother and baby institutions, Magdalen laundries and workhouses, and redress scheme bill. Are members in agreement to provide a no response?
Agreed, because I think it'll be done on a party basis, wouldn't it? Mostly, in
Yeah.
terms of specifics.
Item 10.
Sorry, Chair, just a minute.
Justin.
How does clerical abuse fit into that? Are they two separate realms, or where does clerical abuse fit in?
It was being, I thought that the clerical abuse stuff was being done through the historic institutional abuse stuff. But I'm not sure, Justin, because as you'll appreciate, I've kind of got enough in my hands with justice than to be covering TEO committee's work, so I'm not fully au fait with those. But I had felt that, or my understanding was that clerical stuff fell into historic institutional abuse and wasn't just the mother and baby institutions, but I'm not sure. Deirdre?
There's probably some crossover, obviously, because the institutions managed some of the facilities, but I don't know, it may be worthwhile in terms of if they're looking at the public inquiry element of this, that may be a strand of the work included, but it's probably better asking, TEO that.
Yeah, well, how about we write to TEO and ask them where clerical abuse is fitting into, the various
And will they be
abuse
pursuing a
and-
public inquiry into same?
will who be?
Executive office.
That's a question for the executive office, I think, not the TEO committee.
Committee, yeah, okay. Just where it sits, and then I
See
can
that
issue
point?
that.
See that point that you raise? I think that's one for a written question. So make sure you get it in before tomorrow, because and actually that information would be useful to know, Justin. Right. So we're going to provide a nil response, but we're going to ask the question of TEO around where clerical abuse is fitting in, and we'll see what they say about that. I mean, there's bound to be an element here, I would have thought, bearing in mind the nature of the institutions and who was running them. So, yeah,
100%.
but I had understood it was a bit beyond them, because when you take into account schools and all that too. Right, item 10.4 is correspondence from an individual regarding personal issues at page 507 to 537 of the meeting pack and pages 19 to 27 of the table pack. The members of the committee clerk is seeking advice on this item of correspondence given the nature of some of the documents received. Are you content that any draft response is circulated for approval via email in advance of issue to the individual?
Yeah.
Thank you. Are you content to note the other items of correspondence as set out in the memo, or do you have any comments to make on any of them? Anybody have anything? I just want to do a last quick. Kira, you've got stuff.
Just on 10.15, and obviously it's in relation to the family courts, which is another key area that we've had many meetings and conversations about. I suppose first and foremost, could that correspondence be also forwarded to the Finance Committee for consideration? And then it's just a question, not just on the 1995 Children's Order, when does or can there be a continual impact assessment of legislation, as we have legislation since 1995, and over time how it's implemented and the impact of it?
Tell me this again, Kira.
Obviously the 1995 Children's Order that's pertinent to this in relation to the family courts, and obviously the core element of obviously contact and how that's applied in courts. And we know there is grave concerns that many feel that the law is being interpreted differently and not consistently across the courts when it comes to contact, and they're requesting that there is a review of the impact of the legislation, which is 30-year-old. So I'm wondering, is that something that a department does on a regular basis, first and foremost, or is that something that a committee would need to request? Because I know in any new legislation, I know I'm only here a few years, but we always have an inbuilt review of the legislation, say in 3 years, just to see how it's actually operationally working, to ensure that it's fit for purpose. So in relation to this, the 1995 Children's Order, which they're requesting for the Finance Committee, is that ongoing anyway with departments? I don't know.
Any ideas, guys?
I don't actually, and I don't know how you would go about getting that information either. I suspect the short answer is no. As you said, now some reviews are automatically built in to some pieces of legislation. And obviously it depends on, I think this committee has been actually one of the forerunners in this in the previous mandate. I wouldn't imagine that it's something that's done routinely, and I think that's probably why one of the things, Chair, that CLG had agreed in the last mandate and that is being taken forward and is a subject of much more focus, and will be the subject of much more focus, is post-legislative scrutiny, and I think it's probably for that reason, one of those reasons anyway, Ciara.
So, Ciara, on your first point about forwarding that, we'd need to get the individual's permission.
Yep.
to forward it. If we get the individual's permission, you can tend to forward that to, was it the department or the committee for finance you wanted?
The
Both?
committee.
Committee for
On
finance?
to
It went to
Went to
the department,
right.
but should go to the committee as well.
So, if we get, are you content with that first of all?
Yeah, is there an agreement?
I mean, do you want us to write and ask
I'd write to ask.
whether there has been or there's an
Intending to.
intention to review?
Yeah.
Department of Finance.
Yes.
Yes, bearing in mind some of the issues that are being raised regularly. Okay. The other thing I want to flag up is you'll see that we're on a targeted list of consultees from the Lady Chief Justice about immediate access to the Family Courts pilot. Now I note that this consultation closes on the 8th of September, which is before we're back. I'm wondering, should we at this, would the committee be wanting to respond to that consultation? If we are, we could ask for an extension.
Extension, I think that would be good, and then consider it.
It'll be a
Yeah.
party response
Yeah.
rather than a committee response, wouldn't it?
Well, see, it's a targeted one, so it's not, there's a list of set people, so people can't really. So,
I think to ask if people are content, yeah, that we look at it, but ask for an extension then in order to get it in. I'm
yep,
sure they
so
would.
we're content to do that then?
Yeah.
Yeah, right.
Sorry, Chair. In order to do that, do you want me to email all members over the summer and ask for comments to be provided in so that we can draft a response as well? Because I'm conscious that if you do get an extension, it's not likely to be far beyond. It'll be the first couple of weeks coming back. So if we have some information that we can be using to prepare in the meantime, would be helpful.
Yeah.
That's all right,
We'll be
yes. Okay, that's great, thank you. I didn't want that to be going back, I mean, especially, it's different if it's an open call, but that's a targeted one. Right. Let me see those we've done. Are you content to note the other items of correspondence, or is there anything else anybody else wants to raise?
Noted, Chair.
Noted, okay. Agenda item 11 is the forward work programme. You'll see there's a draft committee work programme at page 547. Are you content to agree the work programme, subject to changes that may arise?
Agreed. Just to give my apologies for the meeting on the 18th of September. I won't be here.
Agenda item 12 is chairperson's business. It's standard practice to delegate authority to the chairperson and deputy chairperson during periods of recess to submit views on the releasing or withholding of information in any non-routine or contentious freedom of information request received by the committee, and that any such views expressed would be brought to the attention of the committee at the first meeting after summer recess. Our members agreed to this?
Content, yeah.
Thank you. Agenda item 13 is any other business. Does anybody have any other business they want to raise? Justin.
Sure, thank you. I'd just like to thank our clerks who've been working diligently and methodically and often in painstaking circumstances behind the scenes to keep us updated on all the issues that are really pertinent and important. So thanks, folks. Have a great summer.
I think we're all content to buy into that, Justin.
Guaranteed.
Yes, everybody, thank you very much.
Thank you.
It's been a long road and a busy one, so thank you. Johnny, will you be with us when we come back?
No.
No?
He's gone.
Oh, Johnny.
We're doing the Justice Bill from the Bill Office perspective.
So this is
No
your last
escape.
meeting with us?
Yeah,
We have
yeah.
someone in the
Well, who knows what the future brings, but
But for
For
now,
now,
this is,
yeah.
for now you're departing. Well, on that basis, despite thanking everybody else, I think we'd also want to particularly record our thanks to you. We've loved having you with us. You've put in huge work, and particularly your specialty around post-legislative scrutiny. So thank you very much for all you've brought to the table and for all the advice and support that you've given each of us. So thank you very much indeed,
Well,
Johnny.
thank you all.
We'll miss
It's
you.
been a pleasure.
You'll be missed. Agenda item 14 is date, time and place of next meeting, and that's going to be on Thursday the 11th of September at 2 p.m. in this room. The meeting is adjourned. Thank you.
Committee Room 30, Sound.